Well, a very good morning, and thank you for joining us here on Shop South Mississippi. Today, we are talking with Elizabeth Wynn of Kyle-Wynn & Associates. Thanks for being here.
Hey, thanks for having me.
Absolutely. So, typically, Kyle-Wynn & Associates, you've seen on Shop South Mississippi many times before. We're on usually with Kelly Kyle, who is your law partner, and then we're usually talking about workshops that have to do with estate planning, elder law, nursing home planning. Today, with Elizabeth, we're going to change gears a little bit. This one is kind of near and dear to my heart, but we're going to talk about estate planning and future planning for those parents who have young children.
Correct.
So we're talking about, like, I have a 3-year-old and a 9-year-old. So we're talking about making sure that things are set up for them in the unlikely event that something were to happen to me. So why is that important?
Well, I think, you know, a lot of people view this area as elder law, which, I mean, that is what it's considered and that's what it's called, but I think that does a great disservice to a large percentage of the population, because especially people with young children, minor children, your 3-year-old, I have a 13-year-old, they can benefit from some level of estate planning because they need to be sure that they have named guardians for their children. So if we are deceased, who do we want to be able to take guardianship of our children and raise them?
Man, that's something you don't think about, but it's a difficult conversation, right? Because you're making sure that your children are cared for. It's one thing to like have a grandparent invite the kids over to spend the night.
Right.
It's another thing to have the grandparents invite the kids over for the rest of their childhood.
Right.
So what is the, I guess for parents, I'm going to just be asking questions that are coming up in my head now because this applies to me. What are some of the things that as parents we need to start doing initially to prepare for that conversation?
I mean, I think considering, you know, your values, what you think is important and how you would want your kids raised if you weren't the one to be able to do it. Location is an important thing. A lot of our clients, young parents, come in and, you know, they may have a friend or a close family member that doesn't live anywhere near them. They would love for that person to be able to take custody of their children, but not necessarily the best option because of the fact that they wouldn't want to uproot their kids and move them somewhere else. A lot of people consider religion, you know, school, where their kids would go to school, all of those things matter. Well,
and the majority, all of my family are in this area. So, and listen, if my mother's watching, she's going to feel this internally as soon as I say it. It took, I'm 47, right? So it took me long enough to get her a grandchild that she was begging for. So imagine you put your children in the care of someone else that now takes them away from that family unit that also existed without the parents, the cousins, the aunts, the uncles, the grandparents. So you want to make sure that you're keeping that kind of, that unit together, right? Is that important?
Yeah, I think so. I think that goes kind of back to location. If you're going to leave guardianship to someone, you want to make sure that they have the ability to still spend time, especially after such a tragic loss at such a young age, that they still have their core and nuclear family members around them, you know, afterwards.
Do you find that when this planning part doesn't happen that it gets a little chippy whenever, and you know, it's family, right? So you don't expect things like this to take a turn, but typically that's what happens. Do you find it happens more often than not that if these plans aren't settled beforehand, it becomes kind of a battle?
Oh, absolutely. It certainly can, because, you know, maybe not every, but most family members think they would be the best choice for that position, and it can certainly lead to long drawn out court battles over who gets to, you know, be in charge of that child and who gets to take care of them if that were to happen.
And you know, court battles are not relatively inexpensive.
Right.
They usually cost a good bit of money, and it's better to prepare for that and pay for that on the front end than have to maybe, you know, on the front end it costs a lot less because you're deciding it, it's done.
Right.
On the back end, it could take months or years to have that conversation in front of a judge.
Absolutely. I mean, that's one of the things that we kind of harp on in estate planning is that old, I think it was a Fram oil filter commercial, pay me now or pay me later kind of thing. But then the insinuation is it's always going to cost you more on the back end. So you know, you can pay now, you know what the fee is, you get all of that set in place, and there aren't any unknown expenses or issues to deal with on the back end.
On the financial side of it, if you're you know, for life insurance policies, is it best to just leave that, I know every situation is different, is it best to leave that in the care of someone? Is it best to leave it in their name? Is it best to put it in a trust and set guidelines and boundaries on how it can be used?
Yeah, I think that's another important consideration is you really have a couple of different positions that you're wanting to fill. One is the actual guardianship part, who is going to be in charge of the actual child, and the second part is who's going to be in charge of the money. And sometimes people want to separate those two positions. What most people want to avoid, and what I recommend people avoiding, is having a child's inheritance going through a separate court-supervised guardianship. So we typically recommend some sort of trust built into the estate plan that will give, it's called a trustee and a trust, that will give that person a lot more flexibility and freedom to be able to use those funds for the benefit of that child without having to continue to pay court costs and legal fees to ask a judge for permission to access those funds.
Is it best to set, when you're kind of thinking about, you know, if my child, my 3-year-old, like I don't want to leave $500,000 to a 3-year-old, but is it best to set an arbiter that maybe understands the situation, understands the child, knows the parent, knows maybe, like, for example, a family member that is not the sole guardian, but someone who knows what the parent would have wanted? Is that kind of how you steer folks?
Yes, that's exactly kind of how we work that out. That's right.
Well, it's a lot to think about. Did we leave anything out?
I think we've covered all the big stuff. I just think that if more people in our age area with young children, you know, could just get their foot in the door. I know life is extremely busy. We have soccer practices and all of these things going on. But if we can just get you in the door, we can get you taken care of pretty easily.
I think for me, that is what makes the most sense, because you don't with any situation that has to go before a court, you're asking someone now who doesn't know you, who isn't related to you, who's wearing the robe of justice to try to make the best choice for the child, not knowing any of the individuals involved.
That's right.
Or children. It might not be just one. It might be 3 or 4. It might be just 2, maybe 1.
Right.
But you're asking someone else to involve their expertise, their legal knowledge to kind of set the grounds for the situation, when it's so much easier to just do this ahead of time, because then your desire and your will can be administered.
That's right. And their personal opinion. I mean, you know, judges, lawyers, we're all just people, so we have personal things that you know, can affect our decision making. I had a lady whose husband had died when their child was very young, and then when his parents passed away, her minor child received her father's portion of their estate, and she wanted $25,000 to buy a fairly nice, you know, decent little used car for the child, and the judge just had a blanketed rule that said I don't allow more than $10,000 on a vehicle. So it's just a personal thing. Absolutely.
See, listen, if you've got these questions, if you want to make sure you wrap all this up before anything, God forbid anything should happen, give them a call. You see the number there at the bottom of your screen. You see that website, give them a call. They'll answer your questions. Thanks, Elizabeth.
Thank you so much. Appreciate it.